My name is Karen Cohen. I'm a partner at Gentry Locke in the Land Use and Renewable Energy Practice Groups. As a past chair of the Real Property section, I'm honored to now be a part of our section's Living Library project, and I'm especially honored to be co-presenting with John Foote and Ben Lay. The Living Library project is not a CLE. Rather, the goal is to give you some idea of what a land use lawyer does and to highlight the legal issues and concepts that we grapple with most often. John, Ben, and I have all been practicing for a good while, but I did not start in land use law. After I'd already been practicing law for 15 years and not doing real estate or land use, I went back to night school for a master's in real estate development. And so it was there in the business school at George Mason that I had a really great real estate law professor, and it was the preeminent land use lawyer Mike Vanderpool of Manassas. After I graduated, I joined Mike's firm, and there I learned the ropes of real estate, land use, and local government law from Mike and Rick Nishanian, Randy Frostick, and Martin Krim. And when I moved to Richmond to join Gentry Locke, I had the good fortune to have another wonderful mentor, Chip Dix, who helped me take my land use practice into entirely new territory, solar and renewable energy. Serving as co-chair of our section's Land Use and Environmental Committee with Lori Schweller has strengthened my practice too. Thank you to Lori and Williams Mullen for generously providing their Charlottesville office space to us to film this video. It really is the collegiality of the real property section of our bar, and that's really what makes this profession so fulfilling. In this part one, I'll spend 18 minutes to give you some basic terminology and a general legal framework for the land use approval process. In part two, it's just an 8-minute segment where I highlight the statutory framework for challenging land use decisions. And then, once you have kind of these basics under your belt, then you'll be ready for part three, where I'm going to join Ben and John in a lively conversation about what being a land use lawyer means to them, and we'll talk about some of the key legal issues that arise in everyday practice. So first, what is land use law? It's the body of federal, state, and local laws pertaining to how land and structures or buildings on land are used. And fundamentally, it deals with the tension between private property rights and the good of the community. So whether it's, like you see in this slide, a church expanding its footprint, or an Amazon fulfillment center, a Walmart distribution center, a residential subdivision, a solar farm, or an apartment complex, for all those users to get the necessary approvals to use the land the way they want to and build what they want to build, land use law is involved. And so one of the reasons that and I know many of my colleagues, enjoy practicing land use law is that it is interdisciplinary. We regularly work with a variety of allied professionals like civil engineers, architects, real estate developers, planners, environmental consultants, and economic consultants. And land use law, it also really goes hand in hand with local government law. And land use lawyers frequently interact with local government officials and local government attorneys, and that's another really enjoyable part of our practice. So what is the legal framework for local regulation of land use in Virginia? Well, it begins with the Dillon Rule, which says that local governments may possess and can exercise only the powers expressly granted or those necessarily or fairly implied in or incidental to the powers expressly granted. One way it's been put is that a political subdivision of a state is connected to the state as a child is connected to a parent. And the feeling of many Virginia localities, particularly as you get further away from Richmond, is not really a great vibe. It's kind of like, in their view, the Dillon Rule gives the legislature the capacity to, quote, meddle in their decisions. So where do we find these expressly granted powers when it comes to land use? It's in the state enabling legislation, which is found in Title 15.2 of the Code. And this is what authorizes localities to plan and zone and regulate land development through the locality's comprehensive plan and zoning ordinance and regulations. So many of the key provisions that we deal with as land use lawyers are found in Chapter 22 of Title 15.2, which is entitled Planning, Subdivision of Land, and Zoning. Now, there are other important sources of legal authority in land use, and sometimes those matters include federal and state constitutional principles. State and federal environmental laws may be involved, local ordinances that are enabled by the state code, and even charters. Charters are primarily in cities and towns, but Virginia has a few counties with charters, so you must remember to consult those if you're working in those jurisdictions. Now, this general framework underlies all land use, but there is a wide range of complexity in land use. So, for example, if you live in a residential subdivision and say you want to put a deck on your house, you're going to encounter the land use laws, but it's not to the same extent that, say, a data center developer who's looking for an approval for 1 million square feet of data center is going to encounter. As the residential homeowner, you're going to need to consult the zoning ordinance, find out what the setbacks are, whether there's any regulations on height or materials, and you'll need that zoning department approval. And if you're in a subdivision that's governed by a homeowners association, you'll need to check the declaration of covenants, conditions, and restrictions to see whether there are any regulations there that govern decks. But for the data center developer, the process is not going to be, most likely, it's not going to be a simple administrative process. Compliance with zoning is going to be required for sure, but the data center is also likely going to require a legislative approval from the local governing body, that is, the Board of Supervisors for a county, or the city council for a city, or the town council for a town. So it's these kind of legislative land use approvals that we typically deal with as land use attorneys. Barring unusual issues or problems with covenants, a homeowner typically can handle that administrative deck permit on their own without a lawyer. But the approval process for the data center is more complex, and it really could take years, which is important to know, because if you're an attorney working on a real estate transaction, say, and say that the contract says it's contingent on a specific land use approval, then knowing how this process works and how long it can take will tell you that a 30-day study period is not going to cut it if your closing is contingent on a legislative land use approval, such as a rezoning or special use permit. So let's talk about planning and zoning. Did you ever notice that local governments often call this the Department of Planning and Zoning? I mean, why is that? Why planning and zoning? You've got parks and recreation, right? Parks and rec, yeah, there's forms of recreation other than parks, you could see that. But what's the difference between planning and zoning? Well, planning refers to a community's vision of its future development, and that's usually expressed in a document called the comprehensive plan. And that is just usually very general and expresses a vision. It's a guide. Whereas zoning is one of the several tools to help the community achieve this vision. It provides specific rules, specific regulations governing the use of the land. So the local zoning ordinance, that is local law. So here's a picture of a comprehensive plan, and you can see that it is general and visionary, has a table of contents with various topics that plan for the future. Here is a picture of a zoning matrix showing how zoning implements the comprehensive plan. So you can see, for example, across the top, that a locality might have what they call future land use designations in its comprehensive plan. And so, for example, they might say, well, this part of the county should be more commercial, this part should be more industrial, this part should be more residential, and give them certain designations, like COM for commercial. But then if you go down on the vertical side, you see the zoning districts, like B1, B2, B typically meaning for business. And there you'll see that the business designation in zoning is what implements that commercial designation in the comprehensive plan. When you look here at the actual zoning ordinance, you'll see that the uses are typically categorized by those that are permitted by right, that is without the legislative approval process, and those that are permitted by special use permit. Some localities say conditional use permit, special exception. These all might refer to the same thing or different things depending on the locality, and some localities have all three and distinguish them by things such as whether the particular matter would be heard by the Board of Zoning Appeals, which is a quasi-judicial body, versus the Board of Supervisors. So let's assume you've got a client who's under contract to purchase some property, and she's got hopes and dreams of doing some kind of Airbnb thing, maybe with like a wedding venue. And as you can see from looking at that zoning ordinance, there could be more than one use that potentially applies to what she wants to do. You've got here boarding house, bed and breakfast, resort cabin or cottage, all subject to various additional standards that are in the zoning ordinance. So you'll need to know the details of her planned land use and evaluate that against the definitions in the ordinance, which are typically in their own section. Then the next step would be for the client or you on their behalf to fill out an application for the land use approval that's being sought. And that varies by jurisdiction, and typically you can just go to the locality's website and find a link to the application to get the information that you need. After you've filed the application, some localities require the applicant to immediately have a public meeting with the citizens. But whether it's required or not, citizen engagement is an important part of the land use process. You want to know how the neighbors feel potentially about your project, whether there's support or opposition, and you need to be working with the public, hopefully to garner support for your project. Of course, there's always the inevitable opposition, and this slide is just sort of a fun one that shows you some of the acronyms that have emerged in the land use arena. Most people are familiar with NIMBY, not in my backyard. Then there's the NOPEs, say nope to everything that's not on planet Earth. Banana, build absolutely nothing anywhere near anything. And a new one I heard recently, CAVE, citizens against virtually everything. Of course, you know, when you go to a public hearing, you have to think about the fact that who's going to really show up during the week at 7:30 at night. The people who have no problem with your project are probably at home trying to get dinner ready for their kids and are not at your public hearing. So you do have to contend with the opposition. Additionally, you have to contend with the political pressures that the governing body members might feel. And you need to, while you're engaging with the citizens, also engage politically and understand where your home supervisor or council person and all the members of the governing body, where they stand on your proposed project. So while you are engaging with the citizens and engaging politically, that application that was filed is getting sent around by the planning staff to various local and applicable state agencies such as VDOT. And all these agencies, whether it's watershed management or the county arborist or any one of a variety of agencies, will be commenting on your application and providing those comments to the planning staff to provide to you, the applicant or the attorney for the applicant, and the applicant will have a chance to respond to those comments. This process can go in sort of multiple rounds depending on how complex the project is and how quickly the applicant is able to resolve the comments. So bear in mind that this part of the process, you had the application, you had the citizen and political engagement, and now you've got multiple rounds of comments on an application. You already could be many months in. Once staff is ready to produce the staff report, the next thing you need to think about is the upcoming public hearings. And here is where, again, the state enabling legislation is relevant. In 15.2-2204, there are the requirements for public notice for meetings and advertising. Now, you may have seen posting like this in neighborhoods around you where there's signs about a public hearing. Not every locality requires this, and the state code does not require it. So you need to look at the particular jurisdiction to know whether there are posting requirements. Now, let's say you're at the public hearing, the first step at the Planning Commission. The Planning Commission, remember, is a recommending body. So at the public hearing, the Planning Commission will usually take a vote. But remember, the vote is not whether to approve or deny your project. The vote is whether to recommend that the governing body approve or deny your project. So I have here on the slide that little YouTube link just to show you that sometimes these meetings are live streamed or taped. And it's a great way to learn about land use law to watch such meetings. Let's assume that the Planning Commission has made their recommendation. Now remember, they also could defer, and that could add more months to this process. But assuming they've made the recommendation, the next step is to go to the public hearing for the governing body. And there, the governing body, again, may approve or deny or defer decision on the project, potentially adding more months to the process. So the thing to really remember, though, in this game, and you'll probably hear about this more from John and Ben later, there's really only one way to win. You must have the votes. But a reality of land use lawyering, too, is that the only real guarantee about what to expect at a public hearing is to expect the unexpected. So sometimes a supervisor who told you they were in your camp might flip, or things go off the rails at a meeting, and the outcome you expected is not the outcome you get. Other times you may know you cannot win approval, but you need to get the denial in order to comply with contractual terms of a purchase contract that require you to use your best efforts to get an approval, and you just kind of have to go all the way. So sometimes you get that denial, and like a trial that doesn't go your way, it can be a little painful. But let's say the developer wins. Let's say your applicant wins. A majority of the board or council votes in favor of approving the requested rezoning and conditional use permit, and now the applicant's approved for 1 million square feet of data center on the property. So is that it? Boom, you're done? High fives all around? Let's get a shovel in the ground? No, it does not work that way. All that's been obtained so far are the planning and zoning entitlements. Remember, those are part of the legislative approval process for that data center example, where they need the legislative approval. But next is the land development. With those approvals in hand, those would have been based on a conceptual plan or a generalized development plan, sometimes called a GDP. But now the applicant, the developer, and the engineers must refine that GDP and submit it to the locality for site plan approval. So again, that's through the Land Development Division and is an administrative process. But like that legislative approval process, there can be multiple rounds of plan review and comments. So again, you may have more months added to the process. But all right, let's assume you got that legislative land use approval, you got the site plan approval. Just remember that legislative approvals provide that the applicant must commence construction within a certain period of time after that approval. They often do. Some run with the land. Some are only good as to the specific recipient of the approval. So you need to consult both the ordinance and the terms of the use permit to find out. Site plans are valid for 5 years, but remember too, as shown here, that there has been state legislation, and there is from time to time state legislation that has extended those approval periods. First one was due to the housing crisis and then due to COVID. So you never know what's going to crop up there, and you need to pay attention to what's happening in the General Assembly. So now you've got the legislative approval, the site plan approval. Is that it? All systems go at the data center? No, not yet. You still have to get through the building department. That's next, and before a shovel can go in the ground, you need grading permits and all the various construction permits. And then all that work needs to be inspected by the building officials. And it's only then, after all the inspections have passed, that you get to the holy grail, the occupancy permit. And that occupancy permit will allow your client's operations to begin. This slide is just to show you how the terminology for this kind of thing varies. Like in Fairfax, for example, a commercial occupancy permit is called a non-RUP, a non-residential use permit. But if you don't practice in Fairfax and somebody says non-RUP, you certainly should not feel silly about asking what that is, because that's not the same terminology as everywhere else. And in fact, as this slide is intended to show, land use law terminology and all its acronyms, it's hyperlocal. There's all these acronyms for similar things, and it's like alphabet soup. So you will never look silly if you ask for someone to explain what they're referring to. And really, if you don't ask, you're doing yourself and your client a disservice. So always ask, and never, this is my pet peeve, never say permit. Never say permit or allow someone to say permit to you unless they say a lot more than that. For example, go back to your client with the Airbnb wedding venue. The seller's broker has told the buyer, oh, you want that bed and breakfast with the wedding venue? No problem. That seller already got a permit for that. Here, look at this beautiful drawing. It's all done. It's approved. Well, what should you say back? I mean, you should have a ton of questions, right? What type of permit? Was it rezoning? Was it a special use permit? Was there a final site plan approval, a building permit, an occupancy permit? Is this permit expired, or is it still valid? Is it valid only to the original recipient, or is it good as to successors and assigns? You can't just say, oh, we got this permitted and it's all good. So that's a real important point. But there are other land use issues that can arise both inside and outside of the approval process. And each of these topics would really be a full seminar topic in and of itself. So for purposes of gearing up for our talk with John and Ben, I'm just going to highlight a few of these issues that sometimes come up when doing land use, including takings under the federal and state constitutions, zoning violations, your client gets an NOV, that's a notice of violation, and issues involving vested rights and nonconformities. Decisions about private property rights in any of those contexts can result in your client or the applicant or whoever is affected by those being what the law refers to as an aggrieved person. And it's in those situations that decisions are challenged. So the next 8-minute video highlights the statutory framework for challenging land use decisions.